Hi, George Beltakian here, commercial real estate professional in Los Angeles. Today I want to talk to you about the 5 main ways of holding title in California. So title is just the form of ownership to the property. So holding title or vesting in a certain way just means the form in which you own that property and what are the implications to that way of ownership. So first up, we have sole ownership. Sole ownership means there's one individual or one entity holding the property. So if you own the property with an LLC, you have it as a sole ownership under that LLC. And the implications for what happens when that person passes on depend on that person's will or in probate. It could be complicated at times holding it with sole ownership because it's not baked into the vesting. Next up is joint tenancy or joint ownership. With joint ownership, you have a right of survivorship, which basically means if one of the owners dies, their ownership, the interest of the property, goes to the other surviving owners. For example, if you have 3 people owning a property and one of them dies, their portion goes to the other 2 people who own the property. Next up, you have tenants in common. Tenants in common means there's no right of survivorship. So if one of the owners were to pass away, their ownership interest would go to their family rather than the other owners of the property. It would go to their family or their will. Now, one of the key differences between joint tenancy and tenancy in common is with joint tenancy, all the tenants or all the owners have equal interest in the property, right? So if there are 2 owners, it has to be 50-50. However, if they're tenants in common, you could have one owner having 60% of the rights to the property and one owner owning 40% of the property. Tenancy in common is a very common way of holding title because it keeps things simple. If one of the owners in an investment property wants to be bought out by the others, or if they want to sell their own interest to somebody else, or if they pass away, they want to gift it to their family, it keeps things simple because the ownership interest of the other owners isn't necessarily affected. It's more flexible. So next up, you have community property. Community property is typically for married couples and spouses and domestic partners. And there is a right of survivorship for community property where if one spouse dies, the other spouse gets all of their ownership interest. Also, in some cases, you can transfer, one of the spouses can transfer their ownership of the property to people in their will or to other people. In some cases, you can have married couples holding a property without community property where one person owns it, but they specify that they're married, and that's done through a quitclaim deed. So lastly, title could be held through a trust. Now, a trust is technically a legal entity and a way of protecting assets and basically passing on property to family. And there are different trusts with different tax advantages, but typically you're passing on the property in a tax advantaged way, and the trust is what owns the property and is on title. There's the trustor, who's the person gifting the property. There's the trustee, which is the third party managing the property and managing the trust, which owns the property. And there's the beneficiary, which is typically the children or whoever is inheriting the property. Definitely consult an attorney or an estate planner if you're planning on setting up a trust, because different forms of trusts can be quite complicated and have different implications for taxes. Quick recap, 5 main ways of holding title in California. We have sole ownership, we have joint tenancy, we have tenancy in common, we have community property, and we have trusts. Definitely reach out if you have any questions. I'm happy to answer them or connect you with the right person. Please support my channel. Just getting started with it. Like, comment, subscribe, all that good stuff, and I'll see you in the next video.